Well, it's Saturday, December 13th, 2025, and your Lone Wolf Usul is online. Welcome to the Court Gallery. Ladies and gentlemen, you may not know it yet, but you're in for a treat. Earlier this week, I believe it was Tuesday, something like that, we had Judge Simpson with one of our favorite landlord-tenant cases to have watched over the last few months. And ladies and gentlemen, it did not disappoint. It was everything you expect it to be, and it is coming up next with a little bit of Judge DiSanto and Judge Hesselink to follow it, just for good measures. Ladies and gentlemen, I hope you're having a great weekend. It's the end of the week, middle of December, almost Christmas, ladies and gentlemen. Get your stuff in order. It's going to be an interesting season, and we still got another week of court, but right now, this starts right now.
Court calls the case of Anderson versus Lyman. Both matters being called.
I apologize for that interruption.
Not a problem. State your appearance, please.
Good morning, Edward Mall, MAHL P27115, attorney for the plaintiff.
All right, where are we on these cases?
Good morning, Judge. My furnace had went out this morning. Not only did my furnace go out, Lori showed up to my house last month and had some guy walk around the back. But when he saw the camera, he ended up leaving.
What?
When the guy she had moved to the house saw the camera, he ended up leaving. And she's still sending falsified information about the case to the water.
To who?
The water department.
Okay. So somebody last week showed up to your house?
No, that's a video of him walking around the house.
Did you send somebody to the premises?
No, certainly did not.
She was in the car. You can see
And
it in the
it-
She
video.
was what?
She was in the car. You can see it in the video.
Ms. Anderson, you're indicating you didn't send anybody? So she had a video of that? That would,
I didn't send anybody to the house.
were you at the house?
Sorry.
Were you in a car near the house?
And about a month and a half ago, I think I drove by one time, but I didn't drive to the house. I think I just.
Was the car sitting there, ma'am?
Yeah, the car was sitting out front.
No.
They pulled up a little bit.
Out front of
The
the
house. They tried to get out the view of the camera. And then he proceeded to look at the camera. And then he walked around the house and then he seen the camera and then he went back to the car and they pulled up. So he didn't finish walking around the house because he seen the camera.
You have that video
Yes, it's in my camera roll.
on your phone?
Yes.
Did you bring your phone in?
Yes.
Okay. Can you send it to the court if I gave you an email?
Yes.
You know how to do that? And also, you might need to send a copy to These are all non-payment of rent cases, both of these.
There's a lot of issues, but we're slimming it down to non-payment of rent this morning.
Well, from plaintiff's position, what is plaintiff's claim in, I guess, either one of these cases?
Well, at this point, we are concentrating on rent. There's been only how many months? 2 months paid? Only 2 months of rent paid.
So how much are you claiming is owed? How much do you have in this room here?
This includes water, because there's $1,900, more than $1,900 due for water bill for water that was left on. The balance is $15,899.39.
15,000.
$899.39. That gives her credit for the escrow that's with the court of $6,600. 2 payments of escrow have been made only.
She's claiming over 21,000 owing?
Yeah, she figures $22,499.39 is the balance. When I say she, I mean Miss Anderson.
And how much did you say?
66.
So what months is she claiming rent for?
All the months after, well, she has not paid anything since the first the 2 months, May and June. She owes the rent from
So
July.
you're claiming for July?
Yes. August, September, October, November, and December. Not include, yes. Okay, don't. Into the court.
You paid
I know,
what?
we know that.
Paid those months.
Where?
Talking about July and all that, I paid that.
Yeah, July and August have been paid. They're escrow. They're in escrow now. September, October, November, and December.
Just a second, counsel. So you're looking at 6 months, basically, right?
Yes, 6 months have not been paid to us. 2 months have been paid into the court. So this is 4 months owed.
3,300. So, Ms. Lyman, I'm a bit confused because when we appeared here before, you had indicated that you were going to pay the rent into court escrow, and I don't have anything. I only have 2 months in escrow. How much did you pay in escrow this morning?
I paid that $22.70 that I said I was gonna pay.
$22.70.
Yes.
What's this? That's still, but that's not, your monthly rent is 33.
Yes. Remember when I told you how I broke it down for the prorated amount? And that's what I came out to when we were here last time.
Okay, but if that paid, so here's my question. If I have in escrow July, and we'll just call it July and August because those are the latest ones.
And I paid September this morning.
Okay. And then if that's, well, that's the 22.70.
Mhm.
Yes, all right. So without going into even at this point, the difference between the two.
I'm only 2 months behind.
Okay, but where is the 2 months?
I don't have it right now. I was planning on paying at the end of the month.
I don't see how the 2270 pays at September either. And she's prorated it, but prorated, what does it mean? It's prorated. The entire amount is owed.
I didn't get it already.
I understand that, counsel. What did I just say? So you don't have October, November, or December at this point.
The rest I was thinking was planning to pay at the end of this month.
What do you mean?
Like to pay the rest off at the end of this month.
So basically 9,900.
No, it should only been about 7,000.
Why would it be 7,000? Your monthly rent is $3,300.
Yes, only these couple months, I thought it should have been, 7,650. I thought that was all.
Mm-mm.
You know, we've got a copy
There's
of,
6 months that's owed. Okay, I have 2 months in escrow. Right? So now I'm dealing with basically 4 months. You paid $2,270. Again, I'm not going to get into necessarily why you got to that figure. I'll deal with that. I know what I have. But then when I look at October, November, and December, I have nothing.
Yes, because I didn't pay October, November, and then we're just getting to December.
Well, okay. So you're the two, at this point though, there's 9,900 that's owed at a minimum into court escrow. Right? What do you say?
I suppose so, yes. Because I'm confused because I paid her May and I paid June when we first started.
The only thing I'm looking at right now is July through December. I'm looking at those 6 months. And if I'm looking at those 6 months, I have 2 and a partial.
Partial is in September.
Yeah. The $2,270 that you paid today, basically a partial for September. Follow me?
Yes, I get what she's saying. I thought when I had mentioned the overpaid amount that I paid in June and the extra $300 and how much it would have been $533 to be prorated. That's how I came up with that $2,267. Because I only owe 3 months of rent, including December.
I don't know where this proration you have is coming from, where you're taking monies off for September.
Because in May, I didn't get prorated at all in May.
Pardon?
I didn't get prorated at all in May
When you moved in.
Yes,
You moved in on what day?
on the 5th.
But your lease started what day?
Which you started on.
On the 5th. And runs through what?
The 5th of next September. I don't remember the date.
I have a copy of the lease, Your Honor. It starts May 5, 2025. It ends May 4, 2027
May 4th.
of 2027. I have a copy of the, you've got it, okay.
So you follow that, ma'am?
Yes.
So there would not be a proration
How come?
because you would have 4 days in essence at the end of your lease. If your lease ended on the 30th or 31st of a month, I could see and get your argument about the 5 days because you didn't live there those first 5 days. But the way your lease runs, it runs from the 5th, but ends on the 4th of whatever month. So you get all your time. It's just not on the calendar month. basically.
I would remind the defendant that she's ignoring the water bill that's 1,900.
Why are you dealing with that right now? Did I ask you about it?
I brought it up
Did
because
you
she's
need
not,
to remind her of it?
just a reminder of it, yes.
Why?
She's not
I'm
talking.
trying to deal with something right now.
Okay, I'm sorry.
You follow that, Ms. Lyman?
Yes.
So give me a total of 66 plus 2270. 8,870. All right. Yes, ma'am.
I can pay the 533 today for the 5 days.
Say again.
The 533, I can pay that today for the 5 days.
So basically you can make September whole.
Yes.
All right. But what about the other 3 months and why aren't those paid into court escrow?
I got behind. A lot of family stuff had happened, so I had got behind. My plan was to pay those at the end of this month into next year.
Say again.
No, because I was talking about the extra 200 that I paid in June and plus the 300 I was supposed to be getting back that 533. From the deposit, the $300 from the deposit.
For what?
When I overpaid in June, I paid $200 in June, and then the $300 from the deposit that I was supposed to get back.
The 300 from the cleaning deposit?
No,
Or
it was for
the what?
moving in.
Your Honor, if I could explain, there's a security deposit. It was determined by the plaintiff that the security deposit was $300 too much based on the guidelines in this state of Michigan statutes. So she gave her a $300 credit, and it's shown on this ledger.
For June.
But shown on the ledger for the total balance. It's from the balance. The balance, it's part of the number that
But
is
what
taken
month
into
did she
account.
get the credit for? Because
It's not for a particular month. It's just on account. She's saying it's for a particular month. We're saying it's on account.
well, it's got to be for a particular month. When was the security paid?
May security, but it was paid in May.
So if she overpaid the security, that means it's credited toward May rent. Gotta be.
All right, then we have it credited to her on the account, whether it's whatever month it's applied for. She's gotten that credit. It's shown on this ledger.
When did I get the credit? Because nobody told me. He just told that she was supposed to give me the $300 back.
Say,
In June, I overpaid $200 as well.
I get what you're saying, that there was an overpayment in June. But how much did she pay in June? Just
33, she paid $3,300 in June.
3,300?
The rent, and she paid her late fee for June.
Oh, late fee. Okay.
How much is the late fee?
At the time she paid,
How much is the late fee?
the late fee is $150, but I think she may have paid $250. I don't have those records with me. She just put it in my account automatically.
Council has a ledger sheet in front of it. Does that ledger sheet reflect that overpay?
It doesn't. It reflects a charge of $150 for a late fee.
But she said she paid 200 and
Yeah.
something.
Yeah.
Oh.
She directly deposited the funds into my checking account. She didn't give me a pin, and she put an extra $250 in the account for June. She directly deposited in my account.
Okay, I don't care how it got there. Is the ledger sheet that council has, does it reflect that that payment was made?
No, because the letter sheet is just from, July forward.
Why isn't there a ledger back to the beginning of her tenancy? Or if it's just from July forward, why doesn't it reflect? Does it give a credit at the beginning?
She's entitled to a credit of $100 for June.
If I paid,
How do I get $100 when that's not what Ms. Anderson just said?
She paid $250 for a late charge. Is that
Yeah,
what?
she should have
Okay,
just paid.
she should have paid $150. So
She didn't give it to me.
Okay, does the ledger that I have, that you have, counsel, does it reflect that credit?
no,
Why not?
my client compiled this from the date at which the date at which the rent was not paid. So
There isn't a concurrent ledger that's kept?
Well, last time we were
Something
here,
that was made up afterwards?
go ahead and explain when you prepared this one.
I prepared this ledger I didn't know I was supposed to prepare it for the previous month. I just prepared it for July.
Why doesn't her account have a ledger? Why isn't there a ledger that reflects payments on this tenancy? What was the answer to that?
I just didn't prepare a ledger before. I didn't know I was supposed to prepare a ledger before the court escrow.
So how do I find out what she paid in May?
Because
How do I find out what she paid in May?
I can prepare a court ledger for those ones.
But where is that coming from? I don't,
Your bank account show the payments that you received.
Yes, my bank account shows it.
so. And so if that ledger starts out in July, this one that's been created, it doesn't show a credit.
For the $300 overpayment for the
June.
security deposit and the $100 overpayment for the, so we need to.
But you showed.
So I guess what I'm saying is, why come July, if that ledger's to be believed, do I not have a $400 credit, which means that for July, she should have only paid $1,900 or $2,900?
We have a $300 credit on the ledger. We just are missing the $100 credit.
Oh, that's
So
missing.
we're missing the $100.
No. You have it at some point on that ledger, right? But if you created a ledger that accurately reflects this tenancy, that means her opening balance that she would have owed as of July 1 would have been $2,900.
Yeah, but
Yes.
yeah. So I can.
Yep.
And so, counsel, the amount you gave me of the 22,499.39, I think it is. Did that reflect $100?
No, I did not know about that. So it's 22,399.39. minus the escrow.
How much did she pay in security deposit?
The 525 plus the 750.
And where is that being held?
In my name,
In what?
in my name.
Is it in a separate account?
Yeah, can I explain something?
No,
Just-
answer my question.
Yeah, yes, yes.
Where's it being held was the question.
Oh, Chase Bank.
In a separate account.
Since then, I've moved.
Is it in a separate account? Has it been in a separate account from the beginning?
No, because I actually moved everything over to LMC.
So I don't know where her security deposit is.
You said it's a Chase or it's been moved
It's
to,
to I actually closed the Chase account down, and it's my LMC account.
what is LMC?
It's like Michigan credit. It's just that I was getting charged too much.
Okay, just tell it, Judge, where it is. What
Yeah.
bank is it?
LMC.
What is LMC?
It's like Michigan
Did you
credit.
notify the tenant that that's where the security is being held?
No, because no, sir.
Is it in a separate account at this new institution?
No, sir.
It's just commingled with your account?
It's actually the savings account, so I don't.
Is it commingled with your savings account?
No, I have a separate savings account and I have a separate checking account.
I'll try the question again. Is it in a separate account that delineates it as a security?
Separate.
So it's in your savings or checking account?
Yes.
It's commingled with your funds?
Yeah, but I don't spend.
It's commingled with your funds?
Yes.
Did you send that?
Yeah, I sent it.
Who'd you send it to?
I sent it to the district court.
Oh. They gotta pull it for me. That's all right. We'll get here.
Oh,
Well, tell Ann, please. So, Ms. Lyman, how much are you counterclaiming for?
We have
Half of what?
escrow amounts that I paid.
I'm sorry?
At least half of the amounts that I have paid in escrow.
All right, and on what basis are you claiming that money should be paid to you?
What do you mean by that? Like, why?
Meaning, why should I give that to you?
Because I haven't been able to live peaceful.
So interference with your,
My peace,
all right.
my mental,
Any other reason?
mentally, emotionally, just the stress.
All right, but this is a contractual case, so some of those damages aren't there. But you're basically claiming an interference with quiet, useful enjoyment of the premises.
Yeah.
And how much is the plaintiff claiming in additional water?
The water bill is 19, this is just for May 5th to December 8th, is 1915.80.
1915,
Yep, 80.
80?
And the water bill, I had a payment plan. I had a plan figured out. And when I called, They said she called and took the water out my name, put it in hers, and paid it. And then I sent the
Did
email
you
about
do that?
What happened was.
No.
Yes,
Did you do
yes,
that?
because he said it would go to my tax bill, if she didn't accept the payment plan by that date, the 13th of October, which she did not. I have the manager of the utility company said she did not do that, and so I came in personally and set it up and paid it with borrowed funds, so that it wouldn't go.
I don't care where the funds came from. You paid it.
Yes, so it wouldn't go on my tax bill, because that's what they do. They don't.
I understand what they do. I didn't ask all that.
I just was protecting myself.
So the water bill's been paid.
Yes, sir.
Do I have a receipt for the amount paid on the water bill?
Yes, sir.
When I talked to Landis.
There's been 3 bills.
We have one bill here.
We submitted everything to the court.
Well, we don't have it right now. This one bill.
$13,1583.
Yes.
We'll just show that to Lyman.
Okay. All right. It's okay. It's okay. Okay.
All right. Ms. Lyman, you saw that water bill?
Yes.
Okay. And that was the amount you were going to set up a payment plan?
Yes, that's when I called to set up, they said like an hour and a half or an hour. She had called in, took the bill out of my name and put it in hers and paid it. And then when I emailed about it, she had said, oh, well, you can just pay me now. That's what she said.
Okay, but you're not disputing that that's a water bill you would have had to pay.
Yeah, that's what I would have had to pay.
You would have had to pay that 13. Yeah, you would have had to pay it anyway. You were just going to do it a different way with the township.
Yes.
Okay, all right. So you're not disputing the figure.
No, that's the amount that I got billed for. I had a payment plan worked out where I was just going to pay it over time, not all in full at once.
Where's the email that says that it was going to go to your taxes if it wasn't paid or an arrangement not made?
I can get an email from the township.
I don't, you said there was one.
I have an email from the gentleman. I emailed it to the court. I CC'd the court. It's in the court record.
It doesn't immediately go on your taxes in any event.
They said
It doesn't immediately go on your taxes. I know how it works.
I didn't work at it. Sorry.
She took it.
So why did you take it out of her name?
This is from Cindy Roberts.
Why did you take it out of her name?
Because I had to pay it on the 13th.
But you could have paid it and it stayed in her name. Why'd you take it out of her name?
I put it back in her name, but I just had to pay it.
That isn't an answer to my question. On the day you went in to pay it, you're telling me that you paid it because you were worried that it was going to go on your taxes.
That's what Cindy.
Okay, that's fine. It doesn't quite work that way, but that's fine. But then the question becomes, why'd you take the water bill out of her name?
Because I wanted to be responsible, so I wouldn't get behind.
But that's not what the lease says, does it?
It says it could be, the lease says it could be paid by me and then she reimbursed me. You know, so I was just gonna give her the benefit.
Why was it put in her name in the first place?
I was giving her the option of being able.
Why was it put in her name in the first place?
They told me at the township that it could be put in her name if I wanted it.
Okay, So then it's put into her name. So then it comes down to this date. Why do you change the name on it?
On the 13th, they said if the water bill was due, it wasn't paid. I came at like 2 o'clock and they closed it.
Why did you change the name?
Because I wanted to be responsible for paying the water. I didn't want it to get behind again.
And so you couldn't be responsible without changing the name?
I could put it back to her name.
That's not what I said. You're telling me that you had to change the name so that you could be responsible for it.
So that you could send me the bills and I can keep up with it and pay the water bill.
They would send you the bill anyway. You can always go online. You can look it up.
I just was concerned. That's all, sir.
But why was it important for you to change the name?
I thought I needed to be responsible for it. That's all. I just wanted to make sure I got the bill.
You're the homeowner.
Well, maybe I didn't know. I just did the best I could.
No, you did that to harass her. Because you could have paid that bill. At any given point, you can go right online and pay that bill.
Well, I thought
They don't care who's it's coming from. If that money is there, it's there.
the lease says that I can pay the water and she would reimburse me. I was just giving her an opportunity to put it in her name.
It was already in her name.
Not from the very beginning. It was in my name.
Was it in her name?
Not in May when she moved in. I put it in her.
That was the first month.
I let her.
In June, was it in her name?
No,
July,
no.
August,
I let her put it in August.
September,
Yes.
October.
I'm going to recollection. I think I took it out of her name in October. So I think I had it in her name 2 months.
Oh, dear goodness, why? Why'd you do that?
I just wanted to,
That was a question.
I was just trying to get it paid, so. Sorry.
You would agree with me, Miss Anderson, that you could pay that bill without changing the name. You know at the time you paid it, you didn't need to change the name, didn't you?
Do you want me to change it back, sir?
No, that's not what you knew at the time, that you didn't have to change the name.
Did you know or did you not know that?
I didn't.
She said she didn't know that.
Okay, all right. Counselor, you gave me a number at the very beginning of 22,49939, which has been changed to 22,39939
Yes,
as the total rent.
yes. Not counting escrow.
Right, not counting the escrow.
Right.
When you gave me 33 times 6, you gave me 1,900. So just so that I'm not double counting, I get for the 6 months of rent, I get 19,800.
Let's see, 8, 1, 3, 6, 19,800. Yeah, that's what.
Yeah, that's what I get for the 6
You don't have to
months.
point that out to me. I understand that. Okay. 19,800. That's correct for 6 months.
Okay, so what's our difference? When you gave me the 22, now 399, you gave me 22, basically 499. And then, but when I count the 6 months, I get 19,800. So I don't,
Okay, well, we also get 19,800 for 6 months, but we add to it the water bill of 1950 and 80.
gotcha. Okay.
And we get the court costs of 183.59, and we get late fees of $900.
Late fees of 900.
Yes, they're 150 per month.
Were late fees subtracted out for the payments made into court escrow?
She was late every time it was paid.
Why can't I just get an answer to my question?
No, they were not taken into account in the
Thank you.
money she paid to the escrow. She paid $3,300 twice.
So I want to be clear on this, Ms. Anderson, because Ms. Lyman is claiming, and throughout the course of this case, and counsel, you haven't been here while it's been going on. She's claiming interference with her possessory interest. Right.
No, sir.
On the day that Ms. Lyman is claiming, before I go back and look at this tape, did you send a gentleman to the premises? Make sure you give me a correct answer.
That was your question? Okay.
Did I send a gentleman to the house? No. She said I was in the car.
You have also, to this court, indicated you were not in the car in front of the house. Is that correct?
Sitting in the car in front of the house? No, I drove by one time. Just to check on the house. I've driven by one time in 4 months. 4 months I've driven by one time.
He's not asking about that.
No, I was not in front of the house waiting for anything.
Do you know anything about the gentleman that came to the house and came around the back of the premises, as Ms. Lyman has indicated?
No.
Ms. Lyman, just to be clear, what date was that? November 10th.
At like 9 in the morning.
She has not.
She is not. She's asking.
Yeah.
It was like the same outfit like on today. It was like a tannish, little pinkish color that you
Tannish.
like the hijab.
Okay. Give her Ann's email and have her send it.
Because it wasn't the first time that somebody had walked around the house. She sent, I believe, her contractor before it on.
A lot of Muslim women in the neighborhood. A lot of women wearing jobs in our neighborhood.
And what's your argument in terms of the interference with her possessory interest?
There's been no facts presented other than this person who walked to the back of their house about interference with her possessory interests.
Okay, so that, and I hear you, counsel, but can I just say that? And again, you weren't here when that other case, and when I was coming back to you by decision, actually, she's put forth other claims of where your client has gone to the house. This one that she put forth today is one that wasn't included in that.
Well, I know that you were not again. What the heck? I'm sorry.
The only time I was at the house was when he was court ordered. I haven't been at the house since. I don't go to the house.
Oh, okay. All right. There was a court. I know that there was a court ordered inspection
Yes.
house, and she was.
Because there had been problems with coming to the premises and then claims that she wasn't able to get in.
Right. You were here. You were there at the inspection, right?
Yes.
Okay. She was there at the inspection.
Correct.
Me and I.
Okay.
But I haven't been back
You've not been there other than.
other than driving by.
You already talked about driving by.
Yeah, just to make sure the house is still there.
There was not. You've not been on the premises
No,
except for
Have
that
you
inspection.
sent others on the premises?
no.
You not authorized anybody to be on the premises, Miss Anderson?
No, I don't even know if it's still there. I drive by every now and again, to make sure it's still there. But I don't.
Okay, you already said that. Okay.
I'm gonna say, counsel, that, and again, you're at a slight disadvantage that doesn't quite fit with what's been presented to the court previously. So, all right, you sent that video.
Yes, I see.
All right, so Ann has it.
Oh, she said she'll let us know when she receives it.
All right, so what I'm gonna do is I'm gonna stand in recess, and counsel, I think we have your email.
I don't think so.
No, we don't.
I'll give this lady.
So
Yeah.
why don't you give it to her? And then what I'll do is I'm going to take a recess. When it comes through to us, we will send it right to you, counsel.
I'd appreciate that.
Because that way I know it will go to your phone because you've been answering it all. No, I'm just kidding. All right.
Spam calls that are spam.
No, it's okay. I understand. Our court's going to stand in recess. Everybody can be.
Somebody. Thank you.
The court has had an opportunity to review the videos and submitted by the defendant. Is there anything that plaintiff wants to say regarding those?
We know nothing about the person being there. We don't recognize the person or the car.
And Ms. Lyman, how are you so sure that it was Miss Anderson there?
The guy, he was there before by himself taking pictures inside of the basement. And then
He was what?
there before taking pictures inside of the basement. And then this time,
What do you mean so I recall the issue regarding the basement. You're saying this guy entered the home.
no, he didn't come in. That's who was taking pictures outside in the window. Like through the basement window.
That you had talked about before.
And then I seen her, that's why the hand was up when the car had came back past.
So your testimony is you saw Miss Anderson in the vehicle.
Yes.
On what would have been the third video that the court received.
It was the guy coming back around from the back of the house after he seen the camera.
Well, no, I think I may have received them in a different order. But the last one I had was actually, it looked like the back of the premises and there was a deck.
Yeah.
The camera, the deck I'm seeing, is that the deck that's attached to the premises you rent?
Yes.
Okay. And Miss Anderson, you're indicating that you know nothing about that individual. Miss Lyman, you're sure that that's the individual that was taking pictures inside the premises?
Yes.
I never.
They never came inside. They were just taking a picture from outside in the basement.
Right, right. What were you going to say, Miss Anderson? I want to give everybody an opportunity to say what they're going to say.
I never sent anybody to take pictures of the basement. You said you let somebody in to take pictures of the basement. I never sent
No, she
anybody.
did. She didn't let someone in. He stood outside and took pictures.
I didn't send it, but
Anything else additional from either side before the call rolls?
Not from plaintiff.
Anything else, Ms. Lyman, you want to tell the court?
No, I'm just trying to make sure that the only thing that I have left to pay is the last 3 months, which is the 9,900. Correct?
Well, okay. I'm gonna do it this way. Anything else you want to say? And I'll let you know what you have to pay.
No, not really. I just don't think I should be responsible for court costs, just because when we started coming, the rent was already paid. And yeah, about the water bill, I don't really feel like I should be responsible. Just she took it out my name, paid it herself. But if I have to, I will. Just the company.
What I'm gonna do is I'm gonna render my decision, and I'm gonna do it this way. The original case that was filed, which is, and let me just get it. It's 25-1C-2176. And that's the one that I'm going to render the decision on. One 7-6. All right. And the court has throughout this entire thing, first of all, reviewed all of the documents presented by the parties in detail. And frankly, am unsure, except as to really what is animosity between these parties as to why there is so much stuff here. And from the perspective of the plaintiff, I would just indicate that many of the allegations made by the plaintiff regarding her need to get into the premises, certain things that need to be looked at, and all of those things, quite honestly, the court views as just some pretext to interfere with the possession by Ms. Lyman. There wasn't a need. We went through, and just by way of example, we went through a whole seemed a series of hearings regarding the looking at something in the basement of something that potentially could occur that she wanted to get in the house. But Ms. Anderson was really letting her true motivations be known, because every time she would indicate that she needs to look in to make sure that the premises are in some way damaged. And there was no indication whatsoever that Ms. Lyman had done that. She was then at another previous point accusing Ms. Lyman of not being the actual tenant, going so much to the extreme of asking the court to tell her to turn on the camera because that wasn't the person that she rented from and that she was dealing with somebody else. Every hearing, the person that's been appearing has been Ms. Lyman, this Ms. Lyman that I see here today. No one else has appeared. It also seems a bit disingenuous for the plaintiff to say that, because there would have been in-person contact prior to the rental in which she rented to Ms. Lyman and the like. Ms. Lyman may have had people there. She may have had other things, but Ms. Lyman has been the one here and been the one taking responsibility for that. So I don't think that Miss Anderson, frankly, I'll just be blunt about it. I think she wants to have control of everything, including Miss Lyman, what Miss Lyman's doing, who Miss Lyman has there, and the like. And none of it makes much sense to me. If she wanted to inspect for damages mid-lease, then inspect for damages mid-lease. But she came in here accusing Miss Lyman of fraud. That has not been substantiated in any way whatsoever, that Miss Lyman was somehow fraudulently renting the premises. It was just said that that was it, and that it wasn't Miss Lyman. And, and just over and over doing that. And I don't know why Miss Anderson wanted to do what she was doing, but it just throughout the course of these proceedings and hearing after hearing, just this sort of berating of the tenant, saying that she wasn't doing something, just continued. While I've heard what Ms. Lyman has said and said through counsel about not knowing that person in that vehicle, I am having a very difficult time believing that to be the case, because there were people coming, testified by Ms. Lyman before, that there were people coming to the premises, all coinciding with Ms. Anderson wanting to get in. Frankly, if this were just a simple issue, and it should be, and that's how the court's going to view this case, it's a simple issue. This is a non-payment case. That's all that it is. There has been no proof whatsoever presented to the court that Ms. Lyman has damaged the premises, is causing any waste or destruction of those premises, or is in any way abusing the premises or violating any terms and conditions of release. But what I do think is that she's been harassed by Ms. Anderson. And while it may not seem much, when the water bill was coming out, and that kind of popped into this case at some point, she was even in court berating the defendant about paying the water bill. Now, certainly the water bill should be paid, and there are just different ways that landlords go about doing that. But she just continued to go after Ms. Anderson about paying the water bill. Kept saying the water bill was somewhere around $1,800. The only bill that I've received today is for $1,315.83. She claims that there are these other payments. I don't know that to be the case. But that's all I have in terms of the water bill, is the $1,315.83. I then have, in terms of rent not paid, and I think it was explained to Ms. Lyman that the rental period starting on the 5th, but her lease doesn't end till the 4th day of the end of the term, is that 30-day or month period. So it's not like she's being shorted. She's not entitled to any type of credit for that. But as it regards the rent on the premises, there's a total amount of $19,800 owing in rent. So when I take that and the water bill together, which the water was supposed to be paid by Miss Lyman, I come up with a total amount of $21,115 that is owed by Miss Lyman. Now, I've not made any deductions for what's been paid in at this point. That would be the aggregate amount due. I am concerned that there are then these additional late fees added on. And late fees should not have been charged for the defendant. Whether she paid it to the court late, there are remedies for a landlord. And let me just put it this way. That's part of the problem, is that Miss Anderson tries to make her own rules. And she was paying escrow to the court and should not have then been charged late fees. Miss Anderson's justification, as she blurted out, as she typically does, was that she paid the rent late to the court, so therefore she's entitled to a late fee. Not the way it works. The landlord has certain remedies if she were late paid to the court, which, quite frankly, Anderson has been able to take advantage of with the whole start of the trial in this proceeding by an immediate trial. But it doesn't give you a right to a money judgment, but it gives you a right to an immediate trial. There are those things, but the late fee, not going to do it. So claiming some $900 in late fees, I'm going to take off, because that's what's been paid into escrow. So $300 comes off of that. So of late fees, there is only $600 for late fees instead of the $9 that's claimed. Now, the other problem that I have is that I don't know where Miss Lyman's security deposit is. I can't get a straight answer. What I know is it apparently is commingled with the funds of the plaintiff. It's absolutely inappropriate under our statutes and should be held in a separate account, for which Ms. Lyman, because it was really her money that the landlord is holding, has to be notified as to where it is, the financial institution and the like. That is a clear violation of the law in the way that Ms. Anderson is conducting her business. I also don't know that her counting is all correct, because there were certain numbers that had to come off and come on, and somehow the notice that was sent on this case would have been incorrect. The notice that was sent to the tenant regarding the amount she owed would have been incorrect, because there was at least the $100 credit, and then presumably other credits that went to the tenant. Credits of, and I say it this way because it's money that she's paid. It doesn't necessarily change the bottom line, but it's certainly money that she's paid. And Ms. Anderson knew, or should know, that she's received the funds from Ms. Lyman. But somehow or another, Ms. Lyman has to get herself here to explain to the court that I made these payments. There isn't a ledger, in the sense of a ledger of her payments each month, because apparently Ms. Anderson believes she didn't have to keep a ledger, an account ledger, until the time that she filed the notice, or until, actually what she said is until she paid into escrow. I don't even know where that comes from. That doesn't even make any sense. And certainly it's not a sound business practice by any stretch of the imagination. So what I have is, I have, with late fees, rent, and water, I have the tenant owing $21,715. She has posted, and counsel, remind me, what were your costs that you were claiming?
Costs are $183.59.
Okay. And while Miss Lyman doesn't believe that she didn't have the cost because rent was paid, I don't find that necessarily to be the case. I think the original case could have been filed. But it just wasn't. I mean, it could have been filed. It was filed. I'm not even clear when I look at everything that it needed to be filed. As it seems to me that for the most part, Ms. Lyman finds a way to get herself ultimately paid in full. And I'm going to say this way. I think Miss Anderson was trying to harass Miss Lyman. I've said it in the regard to how she handled her tenancy. But I also think, and this was not certainly counsel's doing, but there's a case that was pending before the court that the court was coming back to render a decision on. And for some inexplicable reason, Ms. Anderson files a new case that then gets served on Ms. Lyman as, frankly, as the court interprets it, is just an added attempt to try to pressure Ms. Lyman to pay. The court never got a straight answer as to why this was even filed. But I just find it odd because also, and falsely, frankly, at least based upon what's been claimed here, in that complaint, she alleged $1,500 water bill, which supposedly was due October 6th. Now, I've never seen a rounded off water bill. I'm sure it exists someplace, but I've never seen one like that. And that's what she put on there. And again, I think it was just an attempt to try to pressure Ms. Lyman into doing something that maybe she was entitled to. But again, I could never get a straight answer as to why this next case was even filed. It made no sense to me whatsoever. This action was already pending, and again, it just made no sense whatsoever from the court standpoint that it was filed. Because of all of the harassment, I think intentional interference with Miss Lyman's quiet and peaceful enjoyment of the premises, what the court is going to do is the court is going to award on her counterclaim on that $1,700 to her. That would bring the plaintiff's judgment to a total amount of $20,015 plus the $183.59. And counsel, I just want to make sure Which case are you getting your cost from? Because is that the new filing or the old filing fee?
We became involved in this case. I mean, in his proceedings after the second case was filed.
Correct. So that I just want to make sure those are the costs you're giving me is from the second.
Well, no, actually, her figure as the costs come from the first case. Is that right?
I was combining.
She was combining them.
Pardon?
She was combining the two cases.
It was the first case. I don't know.
Oh, you don't know. We'll just take the filing fee and the service fee and filing fee was what, $7,575?
No, well, here's the problem. On the first case, I have a filing fee of 130 and a 55 filing fee on the second case.
Okay.
I have a service fee on the first case of 32.30 as well as 32.30 and 32.20 respectively between the cases.
32.30, 32.30 and 32.20.
So, yeah, so here's what I'm going to do. The only cost I'm going to award, counsel, is I'm just going to award the lower of them. And so I'm just going to award 87.20 in cost.
Okay.
Because and again, it's on a case that should have never been filed, but that's the way I'm going to do that. And that would make the total judgment to the plaintiff. If they have me do math here, but 0, 1. I get $20,102.20 is the total judgment amount. And this triangle. $20,120
At $20.
or 20102.20.
All right. Okay.
And then Ms. Lyman has posted into escrow, subtract off of this $8,870.
May I ask, has the court determined that is the correct figure? Because it was 66 when I came in this morning.
There were 66, and then there was another. I had determined that there was
Okay.
2,000. Yeah, posted.
Okay.
Ms. Lyman, you have your hand raised.
Yeah, because that doesn't seem right to me. If I only owe the last 3 months, that's $9,900. With the water bill, that should only be $11,000. And then
11,000. Correct. You know what? I know part of what. So here's what I did. I'm only going to. So the total figure that I came through with rent, water, and late that we just went through is $21,015. Okay. I'm awarding them cost of, let's say,
87.20.
$87.20. Would then bring the total amount of their judgment amount up to $21,802.20.
so even in the prior proceeding, when she said she wasn't counting,
I only gave late fees for 4 of those months.
even though that she had said before.
I understand what she said, but under the lease, she's entitled to.
Okay. Even if she said it, or even if it's on recording that she said it.
So how many times do you think you're going to answer the question and get a different answer from me? Well, I think I'm pretty clear in what I said. And then I'm going to subtract out from that figure the $8,870.
Which gives you 12, 9, 20,
12, 9,
32,
20. All right. So after the escrow is released to the plaintiff, that would lead to a judgment of $12,932.20.
Even though half of those months I've been harassed.
I gave, you need to listen to everything I said. I gave you a credit of the total amount of $1,700. That is for the harassment that you received. Really what is interference with your possessory interest to the extent it was interfered with. I gave a $1,700, which I will tell you historically is a large amount for that type of claim from this court. But I think that,
does that need to come up?
no, I already took it out of here. Okay. So I gave you credit against that amount because this number would be a lot higher otherwise. Right. It is nowhere near the figure that we started out with of the 22, almost 22 and a half that would have been owed, which would have then gotten us somewhere in some bizarre like neighborhood. All right. But basically, if you look at it, Ms. Lyman, effectively, it's going to be the cost, the water bill, and the 3 months of rent plus what's owed on September rent. That's going to comprise that amount.
All right, we will prepare.
All right. So it's the total amount is $12,932.20. Ma'am, I know that you were looking at getting everything paid by the end of the month. How long is it going to take you to come up with that? But you were looking at the 99,
I was looking at the
99, basically 10.
Okay, so I have to pay the water bill in whole instead of paying it in small increments like I was going to do with the water company?
Yes. That was also part of the calculation that went in with the 17.
Right, but I'm saying.
Because I think she interfered with your ability to have a payment plan for the water.
So I can't do the water bill in a payment.
Excuse me?
No, I'm saying I can't do the water bill in a payment plan.
She paid the water bill. You're supposed to pay that water bill as it becomes due. I understand what you were trying to do. Again, in the 1,700 that went into my calculation because and I'm not going to even ask because I don't get a straight answer as to why she did that, took it out of your name and the like. But I've taken all of that into account. And so now I'm asking you, because I also understand that if the water bill were out of the mix, you would basically have around a little over 10,000 that would be due. So let me ask you this. Because you got about 13,000 that you got to pay. How are you going to get that paid? Because you're going to be coming up on January rent also, but this isn't included in this. Let me just ask you this. How much time are you going to need to get this paid?
A little after June.
Pardon?
A little after June.
Like, what does that mean?
Last week of January, February.
I can't give you that long because you're gonna have January rent come again. You follow me? I mean, you're gonna have that next 3,300 click again, which is gonna kick this figure out. And Ms. Lyman, so that you also understand sort of the time frame that I'm working on, so you've got that coming up. But also, today's what, the 9th? So the normal rent date in this case would be the 19th to pay it. But I heard what you said to me about when you were going to get the rest of that. There you go. Here's what I'm going to do. All right. Listening to what you said. The order of eviction date on this matter will be January 5th, 2026. So that amount would need to be paid by that date. Now, so that, and I'm going to say this directly to you, Ms. Anderson, the monies that come in must be applied to the judgment. So if she paid $3,300 and the judgment is still outstanding, apply to the judgment. You can't just say I've taken it as January and she still owes me this. It may be that if she gets that money all by that amount paid and it hasn't paid January rent at that moment, you're going to have to start over on another case. Am I clear on that? Am I clear on it? This is just simple math. Any monies that come in must be applied to the judgment. Don't come back in here having accepted $3,300 saying you're applying it elsewhere.
We understand that, Your Honor.
Thank you. I'll let your attorney explain that to you.
There's one point at the conclusion of this case. What is it that?
The 2 pen drives.
Yeah, she said the court has 2 pin drives that she'd like back.
You know what? She's been bugging me about those things, specifically direct to the court a motion of what you would like returned. And I will look at it, but nothing is going to be returned until the appeal period expires.
I have one other question. Do we prepare the judgment or does the court prepare the judgment?
I'll let you do it. All right. Thank you.
I'll talk to you.
Thank you. And Ms. Lyman, make sure you get a copy. At some point, they'll prepare the judgment. I'll sign off on it. Make sure you have a copy of it. Come up to the court, get a copy of it. Okay. All right. Thank you. So, all right, is everybody here on the explanation?
Yes, sir.
Okay, everybody's here? Okay. You guys have to give me a couple minutes. Otherwise, I'd find somebody to yell at. It'd probably be him. Right? All right, Kurt's gonna stand in for you. No, I'd take her too. Kurt's gonna stand in for you.
All rise.
This is my mistake because I was working off of 2 columns on my, is an incorrect number. The number that she posted in escrow was 8870. But what I didn't do when I redid the numbers in the second column is I didn't take the 17 off. So that the bottom line figure should be $11,232.22. That should be the total amount of the judgment.
11,232.32?
0.20.
0.20.
Yes, sir.
Okay.
All right. Thank you, folks. Sorry about that. That's why I'm a lawyer and not a mathematician. I'll be right back and we'll get the other credit back.
Court changing. All rise.
Call the matter of Charles Abdul Kareem versus Hussein Ali Bazi and all occupants 2502133.
Good morning, Your Honor.
Good morning. Your name for the record, please.
Charles, I'm Abdul Kareem, Your Honor.
Okay, and then we have, Mr. Alabazi is not present. But we have all occupants present. And ma'am, if you can please state your name for the record.
Ellie Getter.
Okay. And so I'm going to have, both of you please raise your right hands. Do you solemnly swear affirm the testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth? Mr. Abdul Kareem.
I do.
Ms. Getter.
I do.
Okay, and if you can please spell your first and last names for the record, ma'am.
My name, first name is spelled Elli, last name spelled Getter.
Okay. Okay, and so, Mr. Abdul Kareem, you're asking for both Mr. Ali Bazi and, Ms. Getter to relocate, correct?
Correct, Your Honor.
All right. Well, you filed this complaint on November 26th. And it claims as though, that Mr. Ali Bazi was personally served at a location in Dearborn.
Yes, it's the business side. Because he no longer live on the property, but this lady had people on him.
Okay. And so, do you have a lease with both Ms.
Yes.
Getter and Mr. Bazi?
I do have a lease.
Okay, I'll take a look at that, please.
Hers, she's not on the lease. Plus, I did leave a
Hold
copy.
on, sir. Hold on.
Copy in the front.
Okay, so, ma'am, do you have a written lease with Mr. Abdul Kareem?
No, Your Honor, I don't.
How long have you been residing at the property?
Since the lease started.
Ma'am, where, does your mail go to the property?
It does not.
So the answer is no, correct?
That's correct. No, it does not.
Okay, and so,
I'm allowed to speak on.
no, not yet. I'm trying to read this, copy, which has half the language, cut off. Is there anywhere in the lease that says that, Mr. Hussein or Ali Bazi is not allowed to have anybody else live there with him?
No, it's not.
No, there's nothing in there?
No, not in the lease. You didn't say you're not allowed to have. But
Okay,
he did specify, Your Honor, says no pet, no dogs is allowed on the property except for service dog or handicap. You look on the last page.
no, I see that. What does that have to do with Ms. Getter living there?
Because I've been to the property twice to do some maintenance on it, and she was not there. And I was told by him the last time, when I did change the locks, that she no longer lived there.
Hold on. You changed the locks?
Yes,
When did you change the locks?
like 2 months ago. But when he requested that from me, he said the maid that come and clean the house, he stole things from his house. So I went to the house and I pronounced myself. Of course, I have to pronounce myself that I'm coming into the property, and nobody was home. So I asked him, I said, what is the girl for what she's done? He said she don't longer live there. So I said, are you lying to me because you don't live there, or you lying to me because you told me that they make store things from your house?
Okay,
Well, answer that question.
so, all right. Ma'am, have you had any conversations with Mr. Abdul Kareem, prior to today?
Yes, Friday.
Your Honor, I have been trying to get Charles's number for,
It's yes or no. Have you had conversations
yes.
with the landlord prior to today?
Yes, I have, Your Honor.
When did you last speak with the landlord?
I last spoke to the landlord, just the other day when I received the eviction notice.
Right. And me,
Hold on, sir. And when you called the landlord, ma'am, what was the conversation?
I let him know who I was, and as soon as I said that my name is Ellie Getter and I live at 9 Walnut, he said, I don't give a fuck. Get the fuck out of my house. I don't fucking care. Get the fuck out of my house. And I said, okay, I guess I'll see you in court. And he said, yeah, see you in fucking court, and hung up on me.
Okay, is that the conversation that you had with Ms. Getter on Friday?
No, if I can speak up.
Did you have a conversation with Ms. Getter on Friday?
Yes. But
Okay,
not tone.
I'm sorry,
That did not tone.
not in that tone.
No.
Okay, so, what was the conversation with Ms. Getter on Friday?
She called me Friday. She said, I have received the eviction note. I said, okay, and she said, me and Hussein, we have a domestic violence or something. So therefore, I'm calling you. I said, why are you calling me for? I have no reason to talk to you, and you have no reason to be calling me. Your name is on the lease. Because the simple fact is, you move your mother to the house, you move your dog in the house, you change the locks without my permission, and now you're calling me. So why are you calling me for? So she said, well, when his lease is up, I said, his lease is not up, which is, I don't want to tell you when his lease is up. She was like, okay, I want to take over the lease. I said, no, you are not F. That's exactly what I said. You're not F.
What's F?
Can I say it in court? Because I'm court.
You need a record.
You are not on a fucking lease, so therefore you cannot ask me when the lease expires for you to take over the lease. So therefore, I would like for you to move out of my property because in the meantime, you are just there as a squatter, but you're not paying rent or nothing.
Well, she has permission to be there from Mr. Bazi.
But who authorized her to move her mama and her dog? And there's no.
Just one moment, sir. Just one moment.
And
Ms. Getter moved in with Mr. Ali Bazi. Mr. Ali Bazi was lawfully permitted to be at the property, correct? Mr. Ali Bazi, no, excuse me, stop, please. Listen to my question. Mr. Ali Bazi has a lease with you.
Yes.
So he is an authorized person to reside at the property, correct?
Correct.
All right. So then he moved the love of his life in, apparently, Ms. Getter, he moved her in, correct?
No,
No, he did not move her in.
no, because I saw her once. Like I said, I was in the property twice.
Sir, hold on.
Do maintenance, you know,
Okay.
there.
Just because you saw her only one time doesn't mean he didn't move her in. She claims she's lived there since the start of the lease.
That's not true.
When did you move in, ma'am?
The start of the lease.
What date?
Oh gosh, I would have to check my records.
Okay, check away, check your records.
Okay, give me 1 second. I hope this doesn't end.
Not yet.
Yeah, you got a beautiful courtroom, Your
Thank you, but please don't speak yet.
Honor. Okay.
Let me see. Let me see. I got the furniture on August 8th. So let me see. April, May, June. It would have been June, Your Honor.
Then you moved in June.
Yes.
Okay, and so you and Mr. Ali Bazi had been dating for how long before you moved in?
2 months.
Mr. Abdul Kareem, do you know Mr. Ali Bazi other than renting him the property?
No,
He's not a family member, a friend of yours, nothing?
no.
Okay,
I'm
and so.
I am on my oath.
I understand. Okay, what's that, ma'am?
I actually initially met Charles to rent the apartment because I picked it out.
It's not an apartment, it's a house.
Sorry, the house. But yes, I initially met with Charles and picked this house out for me and Hussein to move in.
Okay, is that accurate, sir?
Yes.
Okay, so you are aware of who Ms. Getter is?
I'm aware.
Yeah, sir, yes or no? You're aware of who she is,
Yes.
correct?
Like I said,
And she met with you to look at the property, correct?
Yes.
Okay. And so, Miss Getter, why is the lease only in Mr. Ali Bazi's name?
I didn't know then, but I do know now that Hussein was trying to control me. He did not want my name on the lease. He wanted to put it in his business name. He didn't want anybody to know that we were moving here together due to religious reasons. So it was supposed to be like a secret house for me because he wanted to be with me, but he didn't want his family to know.
And ma'am, how did you find the notice for this property?
It was in the mail.
I'm
And I
talking about how did you know that this property was for lease?
a Google search like Zillow or something like that. It was online.
Okay. And so, what is the amount of rent due per month, sir?
3,000.
3,000 per month?
Yes, ma'am.
And, when did Mr. Ali Bazi pay his last rent payment?
September, Your Honor.
And so I understand that there's a PPO. Ma'am, when did you obtain the PPO?
November 24th.
When did Mr. Ali Bazi move out of the property?
It would have been November 19th or 20th.
Okay.
He was trying to break back into the house. He was
Hold
trying
on that, ma'am, I
Okay.
didn't ask for the extra.
Okay.
And you changed the locks?
No,
When?
you check the locks.
No, sir, you testified that you changed the locks.
Oh, yeah, before.
Excuse me, only one of us can speak at a time for the recording, okay? Otherwise, we can't make an accurate record.
Yes, Your Honor.
What day did you change the locks?
That was back in September, I think.
In September?
Yeah.
And that was the last day that Mr. Ali Bazi paid rent?
Yes. His excuse was,
Sir, I'm not asking for the extras right now. Okay, so now my next question then, sir, you said, you testified as well that then Ms. Getter changed the locks after that.
he told me that, yes.
Who told you that?
Who said that?
Well, you can't tell me what he's telling you because he's not here. That's hearsay. So, Ms. Getter, did you change the locks?
I did, Your Honor, yes.
So he's not lying.
Sir, can you please stop interjecting, okay? When did you change the locks?
I changed them November 23rd.
Okay, well, ma'am, Mr. Abdul Kareem doesn't want either one of you still at the property.
I know, I don't want to be here either, Your Honor. I just don't have anywhere to go. I've been in the process of trying to get out. I'm currently in school. I'm almost finished with my schooling. And I will have a job. My house is not going to be done until February 1st. That's why I was trying to get a hold of Charles to see if there was something we could work out. I have a storage pod coming on December 15th to clear all my stuff out. I've been calling domestic violence shelters every single day. Everywhere is full. I don't want to be here just as much as he doesn't want me here. I just don't have anywhere to go. I will be homeless.
Well,
I-
ma'am, are you paying the rent for November or December?
I was not prepared. I've been putting all my money into moving because I don't have a job currently.
Okay,
Hussein was,
ma'am, so let me get this straight. You don't want to move until February when your house is ready. And you also don't want to pay rent at the property.
no, Your Honor, I will, if there's something I can pay, I can't pay $3,000. But I can try to pay something.
Well, I don't think that Mr. Abdul Kareem is interested in that. Are you interested
No,
in
I'm
that?
not interested, Your Honor.
No, he's not interested. He wants 3,000 a month for his property. That's what the lease was for.
Okay, well, can I just have some time to figure out a sooner action.
Well, what does that look like to you, ma'am?
I mean, I will do my best to be out by January 1st. That way I have the pod coming on the 15th. I can have everything packed and I can be out by the 1st.
And then what do you propose to do with the pod? Are you going to leave it on the property?
No, I'm going to move the pod. I'm going to move the pod to my new house until it's ready.
Okay. So, Mr. Abdul Kareem, do you want to agree to have Miss Getter moved by January 1st?
No, Your Honor,
Why not?
because they already in a hole of 2 months rent, and this month that's 3 months now, that's $9,000, Your Honor. I can't afford to have her stay another day in the house without her paying for this month rent. If she wanna stay, she have to pay for this month rent to January 1st, like you said, Your Honor, like you don't move on.
Okay,
Other than that, I mean,
ma'am, so what he's proposing is that he will give you till January 1st, but you have to pay the rent for December because that's due and owing and nobody's paid rent since September.
I honestly, Your Honor, I don't think that he's being accurate about the last time rent was paid. Because Hussein was here all October, all November. So I don't believe he's being 100% honest.
You have something to dispute the date that rent was paid through?
I mean, I don't, but I mean, I don't have $3,000 to pay. So, I mean, I'm working, like I said, I have a pod coming December 15th. So if I could have just until the end of the month, I mean, I didn't expect to be put in this situation. I thought, Hussein was paying the rent.
Hold on.
I can try to get
both of you pause. Both of you pause.
Okay.
So as of the date that the complaint was filed, it says $3,000 per month due the 1st of every month. The last payment, rent is paid through September 31st of 25. I presume you mean September 30th. So that's on the document that was filed with the court. There was not an answer filed. There was not any proof that Ms. Getter has that that rent was paid again after September 30th. And so, ma'am, Mr. Abdul Kareem is allowing you to stay there till January 1st if you pay the month of December. You shouldn't be staying somewhere. You shouldn't be allowed to live for free at the expense of somebody else.
No, I'm not trying to, Your Honor. I'm trying to get out. I just wasn't expecting this.
So if you're
I
able
can
to pay, excuse me.
Okay.
Mr. Abdul Kareem has indicated that if you're not paying rent, he's not allowing you to stay there until January 1st.
Well, when court is over, I can go ask for his rent to be paid. I've already been working with the Community Action Agency, so I can try to get him as much money as possible. I would just have to ask for some help.
Okay, so I'm sorry, so you're working on rental assistance?
Yes, I am.
Okay. Well, sir, I will say that changes things a bit because since she is working on rental assistance, the court has to grant a 14-day adjournment. Okay. So I'll have the two of you come back on December 23rd, which is 14 days. And then I will make my ruling. You'll either have your rent paid or the court will enter an order, a judgment that day.
I thought legally, by law, you only have 10 days to come up with the money, or you can sign the writ of eviction after the 10.
Sir, because she's indicated that she's requesting rental assistance, I'm obligated to set this for 14 days. I cannot set anything within 14 days. I cannot adjourn it for a second hearing or set it for a second hearing within the 14 days.
Yes, Your Honor. If that's what you want, that's fine with me.
Well, it's not necessarily what I want or don't want, right? Ms. Getter has indicated that she's working with Community Action Agency, which I presume she's talking about Wayne Metro and rental assistance.
That's going to take months.
No, it's not, sir. You didn't hear what I just said.
Yes, Your Honor. I'll be back on the 23rd, as you said.
She's requested rental assistance. She has 5 days to file the form that's required. with this court and with you. It's called the DC Form 529. Anyway, there's a form 539, I believe it is, that you need to file, ma'am. She has to file that within 5 days. You will all be coming back on December 23rd. She will either know if that money's being paid. Otherwise, the court will enter a judgment.
Can I have my lease back, please? Please?
Just one moment, sir. I can't do 5 things at one time. Just one moment. All right, we'll set it for 8:30 a.m. on the 23rd. Okay, ma'am, you have that form you need to complete, and then we'll see you all back on December 23rd at 8:30 a.m. And if you can give that back to Mr. Abdul Kareem.
Thank you.
Okay, and we'll see
Thank
you
you.
all back. Thank you.
One question, Your Honor. How do I file? What am I filing and how do I file it?
Well, if you have a question, you should come to the court or you can pull it up online.
Okay. All right. Thank you so much, Your Honor. I appreciate all your help today.
Have a good day.
You too. Bye.
Thank you. Have a good day, sir. Okay. We are on the record in the matter of Sakeb Octar 25205. And counsel,
Attorney Corey Westmoreland appearing on behalf of Mr. Octar. Mr. Octar, would you please unmute yourself and state your full name for the record? There should be a microphone button if you touch the screen.
Hi, I'm Saki. I think it's working. Sorry.
Yeah, we can hear you.
yes,
Can you state your full
your
name?
name for the
Saki
record.
Octar.
I'm sorry, your name for the record, please, sir.
Yep, Saki Octar.
Okay. And so today is the date scheduled for probation violation. Mr. Octar is on probation in this court for operating while visibly impaired. And he was sentenced July 23rd in this matter. And so alleged he failed to appear for a drug test September 8th, was arrested for operating while intoxicated second offense October 4th, and tested positive for cocaine November 4th. Counsel?
Yes, Your Honor. I did have an opportunity to speak with my client regarding the allegations. At this time, we are prepared to waive any sort of contested hearing and enter a guilty plea.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give in this matter be the truth, the whole truth, nothing but the truth?
Yes.
Okay, and sir, you heard the allegations, correct?
Mm-hmm.
Is that yes or no?
Yes.
And as to those allegations, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney for probation violation purposes, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand, sir, that by entering into a plea, you'll be waiving some of those rights.
Yes.
You also understand the possible penalty as a result of your plea, whether in
Yes.
this court, any other court, or administrative agency.
Yes.
And you understand in this matter that it's recommended that probation continue, complete all terms of probation, pay a $50 probation violation fee, increase testing, and serve 15 days jail. You understand that's the recommendation?
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No.
And counsel, you may, what do your client?
Sure. Mr. Octar, are you currently on probation out of the Wyandotte District Court?
Yes.
As a term and condition of your probation, are you to drug test as ordered by probation?
Yes.
Did you in fact fail to submit to a drug test on September 8th of this year?
Yes.
Are you also to not test positive for any sort of drugs or alcohol that you're not prescribed?
No.
Did you test positive for cocaine on November 4th of this year?
Yes.
And did you have police contact out of the Romulus Police Department
Yes.
on October 4th? Okay.
Yes.
And you understand that all those are violations of the terms and conditions of your probation?
Yes, sir.
Okay. Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations, indicate technical violations 1 and 2 for the September 8th and November 4th violations, and non-technical for the OWI second arrest in October. Counsel, as to the recommendation.
Yes, Your Honor. I would just ask that any sort of sentencing be held in abeyance at this time. I know he did have police contact. The contact, without talking about the case, because I don't think he's been charged with it as of yet, but he was pulled over on the side of the road due to a flat tire. Police arrived on scene. I'm not sure exactly where the case is at this point, but I would like you to know that my client starts a new job today. He graduates from nursing school in March. He is signed up for his MAD victim impact panel that he's going to be completing next week. He has taken probation serious. He's completing everything. But at this time, I would just ask that sentencing be adjourned on his behalf.
To what, adjourn until what date, counsel?
Well, just to see if he's actually going to be charged or not. I don't know how long that. I believe there was a blood draw, so the Romulus District Court this time, I believe, is just waiting for the results to come back from the MSP lab.
Well, it does appear that the Romulus Police Department is awaiting those results before proceeding with charges. However, a review of the police report would suggest that there was an issue more than a flat tire. It's alleged that your client was facing the wrong direction of traffic, was unresponsive when the officers arrived, and that there were a whole lot of huffing canisters in the car. So that's what's alleged with that. I don't know how long it's going to take for those blood results to come back, but there's, in addition to that, counsel, there's the matter from September, which your client had the benefit of that being held in abeyance, that violation for failing to appear for a drug test. That was held in abeyance by the probation officer. And then your client tested positive for cocaine November 4th. So I don't know that we need to adjourn sentencing to await the outcome of the 34th District Court matter. Is there another reason that you would like the court to adjourn sentencing?
More or less, Your Honor. I just believe that Mr. Octar is going to be fulfilling all of his duties with probation through this honorable court. Hopefully at this point he sees the light. He needs to get all this behind him and do so without any further violations. And after speaking with him at length yesterday and today, I believe that that is going to be his main focus, to graduate school, get all this behind him, and start a long career of in nursing that will be giving back to the community as a whole.
So are you wanting this court to proceed with sentencing or adjourn sentencing? I'm not adjourning.
I would ask that this honorable.
I'm sorry, just one second, counsel. I'm not adjourning it out to some unknown date for however long it's going to take for those blood results to come back.
What if we just set this for a review in 30 days, and at that point we can assess whether or not he has been charged at a Romulus?
No, I'm not inclined to do that either. I don't see the benefit to adjourning sentencing or having this sentence, tying this sentencing to the the charges in the 34th District Court. Your clients pled guilty to all three matters. So I don't see that there's.
I guess at this point, I would just ask that if you were to sentence him today, that you just sentence him on the 2 violations and not so much the 34th District Court charge.
Okay, sir, if you were to test right now, what's in your system?
Nothing at all. I've been going to my recovery programs every Monday. I also took up a narcotics class at this church by my house that I go to every Wednesdays. I mean, I'm doing everything that I possibly can to stay out of trouble and keep myself busy, especially with this new job starting today. I was laid off from my job, not making any excuses from Delta. So, being on probation, going to school, just, a lot of expenses has really been beating me up. But with this new job, I really feel like I can be on top.
Did you end up getting married, sir?
No, that's actually happening in a couple months here.
Because my note says that you were to be married in Pakistan in October.
Yeah, so that actually got pushed back because of school being where I was in school. I decided to take up extra classes and semester. Just wanted to kind of wrap that up before I, kind of make a very huge commitment, especially with this probation stuff going on. So I just wanted kind of, we just decided that it was better for me or for us to wait a couple months.
So, sir, where is it you're going to be starting work now?
It's for BDR sales. It's just until I pass my nursing state exam. It's a really good job. It's a remote job that, doesn't require me to even leave my house. It's a very, very good job that I've been trying to kind of get into for quite some time now, but I finally landed it. It's a company called Aurora.
So you're not working at Mortgage Capital?
No, I'm still there. Just not at Delta.
So as I was going to continue with my question, you were also working at new sales at the airport.
Yes, that was part of Delta. Yes, ma'am.
So you're
I was laid off from there.
You're still working as a mortgage processor and as a sales representative.
Yes.
And you attend nursing school online?
Yeah, South University.
And how do you perform your clinicals when you're online, sir?
Clinicals, they direct you to the closest center in your area within a 20-mile radius.
Okay. Here's what this court is inclined to do because you have 3 violations, but even if this court were to only proceed on 2 of the violations, sir, you actually had 1 held in abeyance, and then you violated multiple times after that.
Yes, Your Honor. So the first one that I missed, I was actually really, really sick, so I couldn't attend to that. But not making any excuses, like I said. I mean, I take full responsibility for everything.
What's your work schedule at your job, sir?
I actually have a meeting with them. I start my job today at 12, but it's going to be from 9 a.m. to 7 p.m. every day, Monday through Saturday.
Well, how do you do your mortgage processing job? How do you work 2 full-time jobs and go to school online?
Well, the thing about Mortgage Capital, it's that whenever we're busy, like, right now I do mostly refinances, like for processing. So right now it's it's kind of a slow season for us until April or May. So, Mortgage Capital is somewhere where I really won't be working for that long, especially when I start my nursing. This is just it was like a summer type of gig, but it extended out till now because there are some files that we are working on. But it was more seasonal than a full-time job.
All right, here's what the court's going to do. The court's going to order you to continue and complete out terms of probation, pay a $50 probation violation fee. The court's going to order your testing to increase. The court's going to also order 15 days jail and going to suspend 12, so you're going to serve 3. So, sir, when you meet with your employer, you can let them know that you're not available to work. Tomorrow or Friday and Saturday this week.
Okay.
You're to report by Friday, December 12th. Please email them to your probation officer by 10:30 so she can get you set up with all that information, sir.
Okay.
All right. Have a good day.
Thank you.
All right, this is the matter of Sabra Smith and Miguel Morales, file 13-15007-DS, set for a show cause. All right, I do see Mr. Morales is with us. Ms. Spillane, is this your matter?
Yes, sir, it is.
Can you update me on this file, please?
Absolutely. So this matter was adjourned from November 5th to address contempt based on the defendant not making diligent effort to make payments and not making a diligent effort to obtain employment. You had advised him if he paid $850 before today that we could cancel the hearing. However, we have not received any payments since the hearing and no updates on any employment.
Mr. Morales?
Yes,
Are you employed?
I'm not right now.
Why not?
I'm looking for work. I lost my license earlier this year, and that really limited my transportation. Like, I was basically limited to jobs that I could walk to and from, and that was very far and few. Since my last court date, though, there's been a couple of things that came up. I had an interview, and I've been working with Northern Staffing, temp agency in Petoskey, and they have a position it's called SimTech in Boyne City. It's a factory they want me to start at. As of right now, I just had a surgery a few days ago, so I'm recovering from that. It limited my mobility a little bit, but as soon as I've recovered from that, they said I should be able to start at this position.
How are you going to get there?
It's pretty close, and there's a certain amount of overlap between when my girlfriend goes to work and when I would be starting this job that she can get me to work. I'm just going to have to bring a backpack and lay her up and hoof it to get back home. It's only a couple miles away from our house, but that's just sort of where I'm at, and that's what I have to do. So,
when did you have your surgery?
That is a good question. I believe it was this past Monday. It would have been the 8th.
What kind of surgery was it?
I believe. I had lipomas removed from my left thigh. They're basically like non-cancerous tumors, but I had 3 removed from my thigh because they were getting pretty big. They were starting to hurt when I walked.
How long are you off
The
work
recovery
for that?
period, it shouldn't be too long. I'm waiting for the stitches in my incisions to heal. So a couple more weeks at the very most, probably, if I were to guess. My instructions from the doctor said, 2 to 3 weeks of recovery.
Mr. Morales, I hear what you're telling me, but I don't know that you're hearing what the court is telling you. You are here for me to address the issue of contempt. I don't know if you understand what that means. That means I'm trying to decide whether I should send you to jail for not doing what you're supposed to be doing, which is have a job and make your payments.
Right, and I understand that, and I'm expressing to the court now that it is insanely difficult to find work when you don't have transportation.
There's a bus system. There are friends. There are people every day who get jobs and have jobs in your exact same situation. They don't have a vehicle. That happens routinely in northern Michigan. You have a person in your household who has a vehicle, apparently, because they're going to work every day, right?
And they work night shift, and it's not their responsibility to get me to work outside of their time.
It's not, but you can catch a ride.
No, I can't. That is what I'm telling you. That is what I've been telling you guys from the beginning. I do not have the support for this.
Why can't, hey, listen to me. Stop talking for a second. Why can't you catch a ride with the person in your household?
I haven't been able to find a job that lines up with her hours. She gets home at 6 in the morning. A lot of these jobs wanted me to start at 10 noon. I can't.
So how far do you live? Tell me where you live.
I live in Boyne City. It is off Silver Street. It's like just outside of town, out of city limits, I guess. I don't know where city limits are. It's not that far, but I have been trying to find work that I have been able to walk to, and I have not been having much success. That is really where we're at. I've been looking for work. I have not found work. Like, it's pretty cut and dry. Like, I'm trying to do what I can. I'm just having trouble.
So how many job applications have you put out in the last month?
In the last month, I haven't put any out because I was dealing with Northern Staffing. They told me that they would have a position. I just had to come and interview with them. And I interviewed with them, and after my surgery, it should be ready to go. Got another week or two at this point.
Your surgery was December, Mr. Morales, your surgery was December the 8th.
Yes.
The order that I entered was in the beginning of November. So there's a whole month that went by before you had your surgery that you could have been working and you didn't.
Okay, well, I disagree. I've been doing what I can, and I'm tired of being told I'm not. I'm tired of it. I have been trying to find work. I have been getting told either A, I don't have enough experience for jobs I have applied to, or I just haven't heard back from people.
You told me you didn't apply to any jobs for a whole month.
Yeah, in the last month. I'm not talking about just the last month.
I am, because that's when I told you to get a job.
I have one lined up, Your Honor.
Great.
I can't do anything about
Where's the money
month.
for last month?
I don't have any.
So why shouldn't I send you to jail?
Why shouldn't you? I don't know. The decision is in your court. I am trying to do what I can. What I can right now is very limited, but I'm trying to do what I can with what I can. And so far, yeah, it's been rough, but I found an end to a place that I'm hopefully going to be starting employment within the next couple of weeks. It's been rough. It's been a shock to me too. I've never gone almost an entire year without being employed. It has been unbelievably stressful. I have gaps in my resume, but not very many, and the ones that I have been justified. So I'm doing what I can. I understand that the process has been unbelievably slow. It is a frustrating thing for me too. But I am doing what I can. I am limited in my resources and my support. But I think, as soon as my leg feels better and my incisions are fine, I think this job is a very decent potential for me. It's not exactly what I wanted, but, when you're at the point where you haven't worked in almost a year, you got to take what you can. And that's what I've been trying to do. I set my pride aside and I tried, applying for jobs that I thought were maybe beneath me, or whatever you want to call it. But at the end of the day, I understand work is work and I need money, and that's what I am trying to do. Because court stuff aside, there's all sorts of personal things that not having money is a stressor for too.
All right, Mr. Morales, I'm going to say some hard things to you, and I want you to just listen to them. I don't want to hear any response from you. I just want you to sit there and listen to this.
Okay.
What I hear from you is you talking yourself into believing that it's okay to not have any work for almost a year, and that you're worried. It sounds to me like you're worried more about your feelings, and you're worried about whether or not a job is below you or beneath you. Quite frankly, that is
no.
I didn't ask you to respond at all, sir.
What you asked. This is ridiculous.
Mr. Morales, I did not ask for you to say a thing. I asked you to sit there and listen to what I'm saying to you.
I don't agree with what you're saying.
Mr. Morales, I did not ask for you to speak. Sit and listen. What I'm hearing from you is that you're not working absolutely as hard as you possibly can to get a job. That is the bottom line. It does not matter what your feelings are. It doesn't matter how easy it is. It doesn't matter anything else. You have an obligation to pay what you're supposed to pay, period. Now, I'm going to give you an opportunity to get this job that you've been talking about. But by all rights, I should be sending you to jail. So I need you to grow a pair and get a job and make your payments. Period. End of story. I don't want to hear any more excuses like you've given me today. If this job doesn't work out, and if you don't make your payment in full by January, we're going to set a hearing in January. And if the payment is not made in full before the next hearing, there is no question. You will go to jail. You will not collect $200, and you will not pass go. Have I made myself absolutely clear?
Crystal, Your Honor.
Thank you. Go do what you're supposed to do. That's all for today. Ms. Spillane, please set this for January the 23rd.
You got it.
Ashley Bagby and David Losievsky, file 14-15600-DP, set for a show cause today. I do see Mr. Losievsky is here. I do see Ms. Bagby is here. Mr. Brzezinski, is this your matter?
Yes, it is.
Can you update me as to this file, please?
Yes, Judge. This hearing was adjourned from November 14th when the court ordered the plaintiff to notify the front of the court upon obtaining employment and to make payments to pay at least the current support obligation until an ordered on arrears obligation is established. There have been no payments since the last hearing. The court further ordered the plaintiff was to provide weekly job searches to the front of the court if they do not have employment. She may do this by mail or electronic mail, and it was to be 10 a week. None have been provided. And the current support obligation is $392 with an arrearage of $19,209.06.
Ms. Bagby, how come you haven't done what I told you to do?
Your Honor, you made $100 payment support 2 or 3 days ago, and I have the receipt. It's on my phone if I can grab that to try and find it. I did make a $100 support payment. And as far as I do have a job. I emailed friend of the court. I have a job at the Hamilton Inn through McNally Resorts. It does not start until January. I did not go in and hand in applications like you said, Your Honor. I was scared, and I hope you understand my fear. I am terrified to walk out of my house. I do not feel safe, but what I did was get a hold of friends, because I am from this area. I did go to school in Indian River, and I got a hold of some old friends who helped me come up with a safety plan to get me a job. I'm going to be working in Mackinac. I'm going to be getting a ride from my roommate because he works in Mackinac also. I'll be working with my friend Rick Caldwell, and he is still very good friends with Cole Brady, who is a sergeant in Emmett County. So if there's any problems there, we have Cole Brady ready to call. And I'll be getting a ride home from my boyfriend. So I will never be alone. I hope that you understand I didn't willingly defy your orders. I just am not safe here in Sheboygan County. When I called 911 here, and David was running me off the road, they called back saying, we can't help you. There's a court order saying we can't. I am not safe in Sheboygan County. However, I am doing everything I can, and it's taken a lot of courage. I lined up a job. It does start in January. I have a ride. I have a way to make sure I am always safe and someone's always with me. And I did make $100 payment. I promise I made it. I promise I made it. I have got the screenshot. I saved it and everything. I'm not sure where you guys have it, but I know I made that payment. I couldn't make the whole obligation.
Slow down, slow down, slow down. Let me check. It's all right. We're fine. Let me take a breath. Let me check with Mr. Brzezinski to see if his records indicate that you've made a $100 payment.
Yes, Judge. I see that one posted. It looks like it posted yesterday in the amount of $97.50.
Credit card fees.
Yep, I understand that as well. So she made it on 12/11.
It looks like it posted. She may have made it prior. I wouldn't have a record of that, but it did post in our system yesterday.
All right. How much is her? You told me, but I've forgotten already. How much is her monthly obligation?
$392.
All right, Mr. Losievsky, when was the last time that you got some money from Ms. Bagby?
It's been several years. I have only ever received, I received one payment of $8.73. I received another payment of $7 and some change. And then I received one payment that was actually over $100 a little bit. It was like $113 or something. And since then, I've received nothing from her ever.
When was the last time that you got a payment?
It's like 3 years ago.
All right. Ms. Bagby, your history of payment is abysmal. You're $19,000 plus in arrears, and Mr. Losievsky is, by all rights, should be up in arms about your lack of payment. It's absolutely ridiculous. I'm familiar with your history. I'm familiar with your claims. Since our last court hearing, I went back and I reviewed all 6 folders that the court system has on your case and your claims. And I've got to say, it's whatever it is that you're doing is not enough. All right. You tell me that you're going to get a job, and I'm going to give you an opportunity to do that. But $100 payment at the last minute is a hope and a prayer that you're not going to jail. By all rights, you should be back in jail. And the only reason that you're not is because I don't think that you're mentally ready to go to jail. And it's not going to do Mr. Losievsky any good to have you sit in jail and not make your payments. So whatever it takes to get you to work and back, I don't really care. You need to do it. So if you need an armored truck to get you there and an armored truck to take you home, then get an armored truck to get there and get an armored truck to get home. That's up to you. That's not the court system. That's not Mr. Losievsky. That's not anybody else. That's you. However you need to be there to feel safe, whatever it is, that's on you. Get a job, get to work, make your payments. So I'm going to give you a whole month to prepare yourself. We're going to come back in January. If you make your payment in full prior to the next hearing, that's $392. If you make your payment in full, you will not go to jail. If you've missed even $1, you're going to jail for 7 days. And we are going to repeat that same process for the next 6 months. so that every month, Mr. Losievsky gets a check for $392 from the friend of the court because you've already made your payment of $392. So the only question I'm going to have for you is, did you make your payment in full? If you have, you get to stay home and you get to continue to work. If you have not, you're going to jail for 7 days, and then you're only going to have 3 weeks to make your next payment. And the payment that you missed is going to be added to that. Do you understand what's going to happen to you?
Yes, I do, Your Honor.
Good. I'll see you in a month. Mr. Brzezinski, could you put this on for January the 23rd, please?
Yes, Judge. Thank you.
All right. That's all for today then. Thank you very much.
Thank you, Your Honor.
Time out. Time out. Wait. Pause. So, big and raid. What the heck? So I guess I need to dig up something new. Somebody was saying that something happened in Middleton's court yesterday. What do we think? Oh, I have something that's interesting to talk about that I haven't watched on my channel yet. It's not Mogan, it's McNally. Would McNally be okay with people? It's the McNally Concord mess. I think this is great. I don't sing. I never sing. This is not a musical. Or is it any sort of acting class? I don't know. Okay, McNally it is. McNally, here we go.
Concord
I'm messing
versus
everything
Mount.
up. Whoa, time out.
Hang on, let me.
I'm pausing because I'm messing everything up. Let me get a few things straight here. Just before we start this proper. I'm gonna do
Concord
this.
versus Mount.
And I'm going to do this. And ladies and gentlemen, Biggin, thank you very much for the raid. And ladies and gentlemen, just because we're raiding, I'm going to extend the show just a little bit further. We got a decent, this is about a 30-minute McNally madhouse right here. Ladies and gentlemen, I hope you enjoy. Welcome to the gallery.
Concord versus Mount.
Morning,
Hang on, let me call the case. 2501975. Thank you. Your appearance?
Morning, Judge. Craig Gallup, P63002 on behalf of the plaintiff, the community manager, Ms. Hope Turner's here.
Your name, ma'am?
Hope Turner.
Your name?
Amanda Mount.
I don't even know where to start on this. I don't even know where to start on this. Ms. Turner, correct me. If I'm a owner of a co-op or a member of the co-op, I should say, do I have the right to get the meeting minutes?
Only if they pertain to that individual, and anything that pertains to another member will be redacted. That's personal information for them. So
you guys don't have anything? You don't have public meeting minutes?
When we have our yearly.
I'm talking about the board meetings.
When we have our annual meeting in June, yes, those go out to the entire membership, and the entire membership is allowed to come to that meeting. That's to speak anything general about the property. If they have any concerns about, rules and stuff, that's our public meeting.
Don't you have board minutes of the board meetings? Is a member entitled to those?
If a member asked to attend a meeting or meet with the board, yes, they're allowed to be in that meeting. We have what's called board briefs that gives the minutes to any member in brief without anything that has to do legally with another member in it. And
I'm going to tell let me just stop everybody here. I'm going to tell everybody my thoughts here. One, let's start with the easy one. You can't submit interrogatories like this, a request to admit like this. You can't do that. I told you you needed a lawyer. I tried to be nice to you. You can't do that. That just borders on harassment and overly burdensome materials. That's all that is. He's right. The court rule leaves you with 20 interrogatories. So to begin with, before I even hear anything, I'm striking your interrogatories and your request to admit from the record. You can prepare those differently. You're limited to 20 interrogatories and 30 requests to admit, period. I'll determine the issue of sanctions later. Now, as to your motion, I don't understand, Mr. And you, I am getting sick of this case. I hate to say that. I should never say that. I'm a judge. I should never, ever say that. But I am tired of this case and all the paper I'm getting. You guys are killing trees. But I gotta tell you, I'm sitting here wondering, I ordered your office, your client, to submit all maintenance logs.
We did.
Okay, wait 1 second. I am not, I want to know what all your responses were, because if you think I got nothing better to do, you two, on a Sunday and go back and look at every single piece of paper on every exhibit here, I got another thing coming for you. But I want you to tell me what your responses were. I don't know the big thing about the maintenance logs here. I mean, the minutes of the meeting. I don't get why all of this was redacted. I mean, if you're talking about attorney-client privilege, you guys are not talking about, you're not talking about work product or attorney-client privilege in a board meeting. The minutes of the board, they're not in there. If they're in there, here's what I'm trying to tell you, Mr. Gallup. I ordered you to produce all these documents. She's leading to me to believe you did not produce the documents that I ordered in my order of October 14 of 25. If you thought that there were items here that were overbroad, covered by attorney-client privilege, covered by the work product doctrine, completely unrelated to anything pertaining to this case, I would have thought you would have filed a motion for a protective order. Said, Judge,
We did.
when did you file your motion for protective order before?
Well, it was on November.
I know, there's so much paper here.
Judge.
Okay, so let's take each one of these. You can start out. Did you provide them with the maintenance log and work orders from July 1 of 15 until the present?
We provided close over 100 documents.
I didn't ask you that.
No, but I'm gonna go through one. I should send them to you, Judge. We were questioning whether or not we should just send them to the court. We're only required to send to the court items that have to request for admissions, et cetera. We submitted over 100 documents, A through F, based on your order that day. So it's disingenuous of her to say that we only produce redacted board minutes. It is an outright lie.
Okay. Direct your comments to me, not to her.
I'm getting very frustrated with the court.
Well, I mean, I don't blame you. I'm
60 interrogatories and the question.
I know, she's not doing that. But let's go back. Do you have the maintenance log and work orders from your unit going back to July 1 of 2015?
They provided all they had, Your Honor. They were provided under, can I send to Jen everything we provided, Your Honor? I had my assistant send it to me this morning.
Jennifer, I don't think I have all this nonsense, do I?
Included in the package, Your Honor. She only included the redacted board minutes, leaving the court to leave all we provided.
Yeah.
A through F. There were A through F because we had 6 or 7 subparts, Your Honor, the order.
I know.
Ms. Turner worked very diligently before we left the conference to produce these documents. I would be happy to produce to Jennifer for the court so you can see what we provided today.
Jennifer, I'm going to have him send
Yes, Judge.
those. Okay, I apologize to you, but I don't know how else to manage this. I'm not doing a very good job on this case. I can tell you that. I give myself an F at best because this has got to stop. You can't send 25, 35 interrogatories, then 60 to 10 days later. You can't do that. I mean, I get the fact that you're enjoying yourself here.
I thought it closed in the 27th, and that was it. I was trying to.
You what?
I thought that discovery ended on the 27th. I didn't get the order until the day of.
I don't know what to do with you anymore, though. I want to be fair with you. I want you to have an opportunity to be heard, but you're papering me to death. I mean, it's not that complex. It's not that complex. You could have taken depositions. You still can do that. I will still give you an order for allowing you to take depositions, but we're not paying for it. That's up to you. You have to hire court reporters. You have to pay for transcripts, not the court. We're not doing that. We don't have anybody in this fight. You filed a motion and then withdrew it, I'm told, asking the court to provide that, and we're not doing that. But I don't know what else to say. I'm supremely frustrated by this whole crazy Hatfield and McCoy case that I have going on. I really am. So let's just start with this. While he's sending those documents, are you telling me that you don't have the maintenance logs or work orders involving your unit back? Let me finish. Dating back to July 1 of 15.
I do.
Okay. Are you telling me that you don't have any billing or financial records related to charges assessed to you or your unit while you resided there?
Assessed to me.
Well, this was your, I was trying to accommodate when I ordered them to provide all this. You says copy of any billing or financial records related to charges assessed to defendant or her unit while she has resided there. Do you have all that documentation from them?
Yes.
How about communications or emails? You don't even know what I'm going to say yet. Between plaintiff and management referencing issues at defendant's unit. Do you have all those? Which ones don't you have?
I don't have any meetings.
Did you provide that?
Yes. No lie.
Okay. All right, now wait a minute. Come on, let's stop with the lie stuff, please, Mr. Gallup.
Judge, this is completely untrue. You know, we have to prove ourselves innocent here, Your Honor.
You don't have to do anything. Let me just do my job.
I appreciate it, Judge, but I'm telling you, the frustration level isn't at it.
I get it. Did you provide her with that documentation?
There were emails, Judge. I saw them this morning. We're gonna send over, there was 100 and some pages.
I know, you guys are killing me. I mean, I have this is not the only case I have.
It is. But
So I'm gonna read 160 of those. How many pages am I reading down the other?
You were under the impression from her pleading that we had only provided redacted board minutes.
Right.
It looked like we gave her nothing.
Right.
Completely untrue. She deceived the court. So we're gonna send you what we provided. We provided her so that you can get an accurate assessment of what we did provide. Ms. Hope worked very hard before the conference to provide this documentation. What we didn't have, we supplemented with 2 affidavits, one from Ms. Turner, one from the board secretary to say why the items that were redacted were in fact redacted, and the absence to anything else that the court may have otherwise required on that October order that you came here with you.
Do you have 100 and some pages of those communications or emails? Did he at least provide you with those?
The only thing
Yes or no?
The only thing I had was the emails that I turned in, it got sent back to me as.
There was an email, at least one or more from Justin Marcus to Justin Marcus and Hope Turner. You remember that one?
Oh, okay, yes, he's very sorry. I'm sorry. I'm so sorry. There was a lot. There was 2.
All right.
Yes.
What do you miss? What did make it?
Because we.
No. Just tell me what you're missing. You're saying they didn't get
this record of our meeting, that was conducted under Robert's rules.
Well, you're asked for communications or emails between plaintiff and management referencing issues at your unit.
And
Did they fail to provide any one of those?
no.
Well, then they provided them.
Well, but
Wait a minute.
provided the board minutes that I asked for, all of them. No,
You're not listening. Ma'am, I'm trying to be patient with you. You're making it difficult. You want to play lawyer? It's okay. But you can't come in here and tell me things and expect me not to call you on them if they're not true. So I'm going to read this one more time to you. Annie, why don't you look at the order? Do you have to have the order of October 14th, right? It's my order of October 14th. Jennifer, can you please bring that down here, a copy of that? Here, John, would you do me a favor, please?
Yeah, I can print another one, Judge.
Good. And then just have somebody run it down and give it to Ms. Mount here.
Okay. Your Honor,
Ma'am?
if I can ask Mr. Gallup how, in what manner those documents are coming over so I can watch for them.
Jen, if you could be, Ian's gonna send it to you, but I'll send you a copy as well. I'll give you email. It's a link. It's a link. It's so large.
Okay, so they're going to come by email, not through M-File?
Correct.
Ma'am,
Okay.
I want you to listen. Here's what you asked for. Did I order them to produce?
Yes.
Any communications or emails between you, between plaintiff and management referencing issues at defendant's unit. Did you supply her with any interoffice communication between employees of Concord, whether it's Ms. Turner or otherwise, and say maintenance workers or anybody else? Did you supply her with all of those?
Everything we had, we provided, Your Honor, and we provided a late breakdown, everything we had. If we didn't have it, we had them sign an affidavit as to why. Either we just didn't have it, we couldn't find it. So everything we provided.
Do you have any reason to dispute that? Tell me if you do.
I do because,
You think they're lying under oath, that they're telling me something under oath that could get them in massive trouble?
I just feel like there would be more considering that I have a pattern.
Considering that you have a what?
Well, that they allege that I had a pattern of behavior, I would have discussions or it's all of it's redacted.
How about this? Any reports or documentation relating to mold at your unit, did you receive those? Did you provide those?
You're Judge. Yes, yes, you did get those.
See, when you tell me no, when I find out yes, and we had this hearing, I'm gonna hit you with sanctions, ma'am.
No, but yes, Your Honor, he did, but what I'm asking for is about the mold, the conversations about the mold regarding my.
You asked for reports
Yes,
or documentation.
right.
You didn't ask them to reiterate verbal communications that they might have had with you. You asked them to provide you with reports or documentation. They did do that.
Yeah.
Meeting minutes discussing the defendant's unit. Did you provide them with all of that?
All meeting minutes that were relevant to her unit. Yes, Judge.
Any reason to dispute that?
Yeah.
Okay, tell me.
Well, I dispute that because, like I said, the meeting minutes should have provided more than what I was provided.
I don't know why you
It
guys
was redacted.
brought to redact all that. You act like you got classified government documents over there.
Judge, with all due respect, this has to do with private member information that we're not going to give here. We've also offered, Your Honor, we've got copies of the unredacted version that if Your Honor.
I will.
I have them on me, obviously, but if you need them, I've had them provide them to me so you can look them in camera. We're not going to give them to her, personal information about other people. These are executive meeting minutes that it's just as important that her privacy will be protected.
Okay, good. Let me move on. Any member complaint logs records regarding defendant's unit since she has resided there. Did you give her those?
Everything Hope could find, she has provided her. Correct, Ms. Turner?
Did you receive some of those?
I didn't give any type of disciplinary record.
They didn't say, you didn't say disciplinary. You said any member complaint log / records regarding defense unit since she has resided there. I presume that you're asking for them to supply you with other member of the co-op's complaints, other members of the co-op's complaints about you, loud music, dogs, who cares, right?
Right.
Did they send you what they had?
Yes,
Okay,
they said, yeah,
so you got,
yes.
and then any documentation or communication between board and or management regarding the mailbox being placed in the boardrooms. Did you provide that?
There wasn't anything here.
Did she sign an affidavit to that
That
effect?
was all part of the affidavit. Ms. Turner's here as well today, testify if necessary. There was never a meeting about this. We're not sure where she came up with this.
Ma'am, do you have a basis to believe that there was,
Yes, because there was a
do
meeting.
you have any reason to believe that they're lying if Ms. Turner's telling us in an affidavit that they don't have documentation or communications between the board and or management regarding the mailbox being placed in the boardroom?
Well, yes,
You do?
yes, I do.
Do you have a document that you have?
That's what I'm trying to get is our.
Well, why do you have reason to believe? I have an affidavit apparently telling me that there are no such communications. Why are you so certain that they have them? They can't produce something they don't have. You realize that, right?
I do realize.
Okay, so why are you insisting that they have something?
Well, because the board president at the time called a formal meeting and it was conducted as of like Robert's rules. And we did that so there could be a formal record.
Oh, so you met with them? You met with them?
Yes, when all this billing was going on.
I'm talking about the boardroom, the mailbox of the boardroom. You met?
That's how that came about in that meeting.
I don't know. You know anything about that, Ms. Turner?
Yes, Your Honor. So Ms. Mount requested a meeting with the board of directors and she had more than one. The only time the board keeps minutes on a meeting like that with an individual member is if there's action items. There was no action items and nothing voted on in those meetings. Therefore, there is no minutes to verify to her for those meetings.
So you're telling the court, and you have an affidavit to this effect, I assume, from Mr. Gallup's comments here, you don't have any documentation or communications between the board or management regarding any mailbox being placed in the boardrooms?
No, Your Honor. The reason the mailbox was in there is because we had the boardroom built and the board wanted a mailbox outside of the office for them to access. That's why the mailbox was installed.
So this is now that I've gone through this, I don't know what they haven't given you. And you wrote this motion like they hadn't supplied anything. You attached all those board minute meetings, minutes of board meetings that were redacted, I thought, to.
That's all we were given, Your Honor. I would have felt the same way, but you weren't given the full picture.
What am I going to do with you guys?
First and foremost, Your Honor, we have a motion that we want this harassment to stop. If she wants to fight, that's what we have the courts for. We can have our trial in January. We still want to try and resolve it if we can, but it doesn't seem like she wants to try it. We are abiding by the court rule. You did everything that you could to try and help her with the discovery process. We went through, I took copious notes and drafted the order myself. Ms. Hope spent, I don't even know how many hours. Ms. Turner, how much time did you spend on putting together that discovery for Ms. Mount?
2 days.
You know, and I didn't even give it much thought. I was just trying to help you along here with your discovery, Ms. Mount. I really was. And you want to insist that there's a conspiracy going, and I don't have any evidence to suggest that they did not comply with the court's order. Now, if they start filing false affidavits, I think Mr. Gallup knows me well enough to know. And Mr. Gallup is an officer of the court, so I know, would not be doing that. They know I'm not going to take that kindly if I find that out. They know that. He knows that. Anybody who knows me knows that. you gotta stop with the inundating discovery requests and the accusations that everything's a lie here. I'm not saying there aren't credibility issues. You may be right on some of this. But you're getting advice from somebody that maybe shouldn't be giving you advice, or you're going on and pulling out pleadings on computers. You did make it sound like they hadn't complied with the court's order at all. And I was ready to give it to him, to be honest with you. You made it sound like they just had not complied with the court's order. Right? And now as we go through all of this, what's that?
That was not my intent.
What was your intention?
Here to get proper records of meetings that we had. If there was that proper, this is what we're allowed to do. As a member, we're entitled to these records. I don't know why they're here. This is why we're here, is all the records.
She specifically signed on her pleading that we had not provided any of the items that you just went through line by line asking for her business. That is a misrepresentation to the court.
It is. It is. You just acknowledge that they provided you with these. I don't understand the big secret about the board minute meetings, though, Mr. Gallup.
It has to do with somebody else in executive session about other people's business when it comes to who's delinquent. If there's other people's units of complaints about that, has nothing to do with her. There's no relevance to her case or anybody else.
All right.
And we're providing our residents the same protection.
You guys give me unredacted copies. I will look. I'll do an in-camera inspection. You're coming back here, or you can appear by Zoom. But ma'am, you are dangerously close to having me sanction you. Well, you can't just make accusations and bring motions, and you did say that.
I have reason to believe there are more.
That's okay. I had reason to believe a lot of things in my life that didn't happen that way. It's just the way it is. You have no proof that they're committing a fraud or perjury or anything else. Just don't know how to handle this. I'm not doing a very good job. I probably need to sanction you. I mean, I'm telling you, I'm going to look at the rest of these documents. Mr. Man, I'm going to look at these documents that he's providing. I've only got about 250 pages for my reading pleasure here. I'll read those. And, you know, you can, I'll figure out what I'm going to do. I don't want you to have to keep coming back on this either, counsel. I mean, I really don't.
Well, we're here today, as a result of what we had in front of you, the items that we provided that she didn't disclose to the court, but we had in fact done so. So we will get you unredacted minutes. We ask that that be held, obviously under seal in your office, Your Honor.
Of course.
The last time we had the same issue again, Your Honor, she filed all those 17 motions before, and you warned her before if she goes off.
I know. Well, I'm not saying I'm not going to sanction her.
I'd like the court to at least reserve.
I am.
Sanctions.
I am.
Fees.
I am.
See what we have.
And I'll take these. You're going to give me your unredacted minutes, and I'll set it for another hearing, and I may very well sanction you, ma'am. So you did make it sound. Look at all these documents. If they didn't give you these documents, you tell me. Have you seen?
No, they didn't.
They did? Well, then why'd you make it sound like they didn't? This has got to be, I embellished. It's got to be 90 or 100 pages here.
I just feel like if there was a lot of issues, as stated, there would be record of that.
You got 90 pages.
And there's none that say I'm stalking or all these other.
Well, then they're not, if they're not providing documents to you, and now it comes out that there were documents that they didn't provide to you, I'm not going to let them use them at trial.
I can tell you as an officer of the court, what you have right there, Your Honor, is exactly what was provided to her. It was a hyperlink that you were provided, and she specifically said, her pleading, we hadn't provided any of those things. This is exactly what was provided to her.
All right, let's just do this. Jennifer, I don't even know where the register is on that case. Would you just make a
Yes.
note that I'm putting this over? And what day do you guys want to come back here? And you're going to drop off the unredacted minutes to me. Well, you can send them right to Jennifer on M-File and make sure you delineate those, that these are for an in-camera inspection. What day are we going to have them back here, Jen?
Judge, trial is November 27th. So do you want December 15th?
No, trial's in January.
No,
Or January, excuse me, January 27th. Do you want to do December 15th?
No, I want to do earlier than that. I don't need
Okay.
that one.
We're going to file that somebody's position motion, Judge.
Yeah. So I'm going to only give.
December 1st?
I can read this at Thanksgiving. So give me a date
December
right
1st?
after. What's that?
December 1st?
December 1st would be perfect. Write that on the
10:30?
register, please. At what
Okay,
time?
yeah, no problem. 10:30.
At 10:30.
And that's going to be a continuation of the motions?
Correct.
Is this in person or Zoom?
But the order, I want striking her interrogatories and request to admit, and you are limited in indicating that she can refile them, but you're limited to 20 interrogatories and 30 requests for admissions. And that does not include subparts. You can't have a question and have 22 subparts. You understand?
Yep.
All right,
And you said 30 and then.
correct. Max,
Your Honor, we are under some hard deadlines here because
I'll probably end up adjourning the trial.
because we're going to want to file this positive motion.
I got it.
So, because we have to file our SD motion by the.
I got it. I got it. I got it.
That's or at least an extension on that.
I will. But we'll work it out. You guys come back on December 1. But
Via Zoom or push.
I don't care.
Because they co-ops and costs, they spent thousands of dollars.
That's fine. Zoom's fine. You can appear by Zoom too if you want, or you can come in person.
So, interesting follow-up. In relation to the December 1st, the reason I'm saying this is possibly still ongoing, he actually did not have a docket on December 1st. This is something I've been looking for. So I'm thinking, quite possibly, that this issue that we just finished watching has been moved to December 15th. Possibly. Not quite sure about that. We'll find out tomorrow. He did not have court at all this past week. Ladies and gentlemen, that's all I have to show you for the time being. I'm sure there's a lot more. There's a lot more I haven't gone through yet, but that's what I've got put together for now. Thank you so much, Biggin, for the raid. Really appreciate it. Love you, guy. Love your channel. Ladies and gentlemen, I am your Lone Wolf Usul. I'm your humble host for these here proceedings. I am your curator for these here videos. Come on by here every single night of the week. I have another set of videos always set up about 8 p.m. Central Time, 9 p.m. Eastern Time, and we're watching court from the day that it happened together and chatting about it in chat. And ladies and gentlemen, I make the videos and you help me comment on them. This is all stuff that we can all identify with, and as Judge Middleton would say, little pieces of shared humanity. Thank you so much for joining me with these offerings for today, and I'll see you next time in the court gallery. I'm your Lone Wolf Usul, and I'm out. Thank you, ladies and gentlemen.